Okay, we will get started, everybody. So hello and good morning. Thank you for joining us today for our CAS webinar on understanding Section 504, who, what, when, why, and how, presented by attorney Michael McKeon from the law firm of Pullman and Cumley. I'm Bill Silva, Associate Executive Director at the Connecticut Association of Schools, and I'm pleased to have so many signing on for this timely and informative presentation. Before I introduce Attorney McKeon, I want to thank CAS's corporate partners, Buffalo Wild Wings, the Connecticut Army National Guard, the Connecticut Department of Public Health, Connecticut Lighting Centers, Horace Mann, Jostens, Liberty Bank, and of course, Pullman and Cumley for their ongoing support of CAS's high-quality professional development for school leaders and all educators in Connecticut. I also want to go over how we will proceed today. During the presentation, you in the audience are muted, but you may share any questions you have using the Q&A feature, and our presenter will try to answer as many questions as he can during the hour and a half we have this morning. We are also recording the webinar, and we will make the recording available to you in the next few days. And now let me introduce our distinguished presenter. Attorney Michael McKeon is a member of the school law section of Pullman and Cumley's Labor, Employment Law, and Employee Benefits Department. Attorney McKeon represents boards of education and other clients in both federal and state courts at the trial and appellate levels, as well as before federal and state boards and commissions. Attorney McKeon has presented on a variety of education law issues, including special education law, gender equality, and student athletics, and both gender and disability-based student harassment. And he regularly provides staff training on education law issues, including Section 504 and Title IX in both public and private schools. Attorney McKeon has served as adjunct professor at the University of Connecticut School of Law and in the University of Bridgeport's Department of Education doctoral program. A graduate of the University of New Hampshire and the University of Missouri, Attorney McKeon received his law degree from the University of Connecticut School of Law. Welcome, Attorney McKeon. We are always pleased to have you at CAS and to have you with us today. We look forward to the information you have to share, and I turn the presentation over to you.
Thank you, Bill. I appreciate it. Well, good morning, everyone. Here today to talk about one of the Section 504 of the Rehabilitation Act. It's an area which I've spoken on a number of times before, and I often find that there are a lot of common misconceptions about it. And that's not a surprise, given that for the longest time, 504 was sort of in the background. Special education, the Individuals with Disabilities Education Improvement Act, or IDEA, was really front and center, and 504 was sort of lurking on the periphery. But it has really come into its own. And in many ways, it's more potent than the IDEA. It's broader based. And it's also, with respect to the remedies it provides, are to a certain extent far more daunting than the IDEA. Because unlike the IDEA, 504 is the civil rights statute. We'll talk a little bit more about that as we go on. Just as first slide is kind of a preamble. It's hard to believe in this day and age, but prior to 504, schools in many states were allowed not to enroll kids if they were deemed uneducable. Let's say they had an intellectual disability, they had a severe learning disability. District said, hey, we can't help these kids. Then they were out of luck, at least as far as public schools go. They also, those students who were educated, they would warehouse them. That's what they used to call it, warehousing, because they essentially put them in segregated settings. And this went on far beyond Brown versus Board of Education, in which the United States Supreme Court found that racially segregated schools violated the Constitution. Nonetheless, the segregation of disabled students was permitted to go on for many, many more years. But finally, Section 504, this changed, and that was followed soon thereafter by the Education of the Handicapped Act, which again is now the IDEA. So it really had very laudable motivations, and has, as a result, brought a lot of children who in the past were stuck somewhere, really basically just whiling away the day, far more into the mainstream. As you'll see, and as some of you who have seen my PowerPoints before, I love colored font. So you'll see colored font as I go along here. Section 504 does not permit discrimination, harassment based upon a individual's disability. It really applies in both the education, K through 12, as well as post-secondary, and also in the employment realm. In fact, the Americans with Disabilities Act essentially took the Rehab Act and expanded it to private sector employers as well, and also some other, when it comes to accommodations, as far as public accommodations, to municipalities as well. So I've highlighted a couple of the more important words and phrases of the statute: qualified individual, any program or activity receiving federal financial assistance. And I'm just going to talk a little bit about them, just because I think it helps to give a sense, an idea of the parameters of 504. 504 only applies to those schools who are receiving federal funds. Now, they can be in the form of monetary funds, grants, services, programs, or even property, which not very typical that the United States is giving people buildings and so forth, but nonetheless, that might occur more likely in the college or university level than with K through 12. But nonetheless, if you receive any financial assistance. Now, I was talking with someone once who was in the private school, and they said, well, it really wouldn't apply to us because we don't get much. We only get minimal amount. We get hardly anything. That makes no difference. There is no cutoff. It's no like, well, if you get below $1,000, you're good. Receive any form of federal financial assistance, you are then covered under 504, and you must comply with its requirements. That's also true with Title VI, which prohibits race discrimination of students, and also Title IX, which prescribes gender-based discrimination. So, as most, if not all of you, are aware of the Payroll Protection Program, the PPP loans, which the federal government instituted in response to the COVID pandemic. So sure enough, along with the PPP loan, if in fact a school got one, and I know there are some schools, in both, particularly the private sector, who did apply and receive PPP loans, along with it came the requirement that you comply with Section 504, again, as well as Title VI and Title IX, but we're just going to talk about 504 today. So typically what happens with the federal government, what one hand gives, the other hand takes. So in other words, it's going to give you these funds, it's going to give you this assistance, but you've got to give something back. I think of the Sidney Greenstreet character in the movie Casablanca when he's saying, for a price, always for a price. And that's essentially how this works. However, the Small Business Administration, which oversees the PPP loans, has taken the position that once the loan is paid or forgiven, the non-discrimination obligations will no longer apply. So if you get a PPP loan and then you apply for forgiveness and it was forgiven, you no longer have to comply with 504, Title VI, or Title IX. I don't know if that's a good thing or a bad thing, but nonetheless, as long as you had the PPP loan, you were on the hook. Once the PPP loan is paid back or forgiven, then, and you are receiving no other federal assistance or no other federal funds, then you are no longer bound by these provisions. Program or activity. Sometimes there'll be arguments that, well, yeah, but only one little program got these federal funds, so it really only applies to that program. That's not how it works. If any program, any school within a school system, and that can be private and parochial as well. In fact, the federal case a couple of years ago out of Pennsylvania, in which an archdiocesan school system one school received a federal financial assistance in the form of some program. And the court held that because the entire system was overseen by the central body, the archdiocese, that even though only one school received the federal funds, that federal assistance was imputed to the entire archdiocesan school system. So every school in that system was bound by Section 504. So again, so long as any part of a school district or a private school, or again, like an archdiocesan school system, is receiving any federal financial assistance, it's generally seen that the entire school district, the entire school, what have you, is bound by 504. Qualified individual with a disability, obviously the crux of this entire statute. It's a tripartite test. You have to have a student, and again, this also applies to employees, but I'm only talking today about students. Student has to have a physical or mental impairment which substantially limits one or more of such person's major life activities. You'll see that as I note here, substantially limits is the most important phrase in Section 504, because that really is the really at the center of any 504 dispute. And it also really comes down to, it's really the determinative factor for the most part as to whether a student qualifies for 504. There's also situation in which someone has a record of such impairment or is regarded as having such an impairment. Okay, let me give an example of number 3, regarded as having such an impairment. This is maybe somewhat dated, but this is the one OCR provided, the Office for Civil Rights, which enforces Section 504, that you have a individual who's a very well-known AIDS advocate for AIDS victims. So they move into a school district and the individual's child, people draw it's kind of a bizarre example, but nonetheless, it's the one OCR provided, is regarded, well, they must have AIDS. That's why the parent is so worked up about it. So they're treated as if they have an impairment when they really don't. Has a record of such an impairment, someone who perhaps had a impairment at some point, but no longer has it, but nonetheless is still treated, is still discriminated against because they say, oh, that person has such and such. I got to tell you, the record of such an impairment or regarded as having such an impairment, in my many years of practicing law, I don't know if I've ever really come across cases that dealt with those two situations. If I did, it was in an employment case involving a worker for a municipality where he was regarded as having an impairment when in fact he did not. But aside from that, as far as school-based goes, as far as students go, I've never had such a case. And really those two situations tend to be more someone who's being harassed or actively discriminated against. So essentially this presentation is going to be focusing on the far more prevalent and day-to-day the student who actually does have such an impairment. Qualified individual with a disability does not include someone who is currently engaging in the illegal use of drugs, and when a covered entity acts on the basis of such use. So in other words, the fact that someone is a drug user does not necessarily mean that they're impaired and they're disabled. Or the fact that some school maybe wants to take disciplinary action against a student for illegally using drugs. The student can't say, well, I'm disabled, I'm using drugs. That is excluded from qualified individual with disability. Now, that's not to say that parent attorneys are going to say, well, the drugs are not an end in and of themselves. Actually, they're symptomatic of an underlying emotional issue of high anxiety, and that, instead of focusing on the drugs, you should be focusing on the underlying symptoms that have led to this drug use. I have heard that only about 1 million times. And parents' attorneys are doing what you're supposed to be doing. So now, if someone is currently participating or has successfully completed a drug rehabilitation program and is no longer engaging in such drug use, this exception doesn't apply. I mean, that's sort of a given because they're no longer using drugs. So in any event. Section 504, and these regulations, again, were written, oh my God, we're talking now 45 years or so ago. So they expressly list conditions, so to speak, that are excluded from 504. And they include pedophilia, exhibitionism, voyeurism, kleptomania, pyromania. So, I mean, I think that maybe the fact that some of these are even included in there could be insulting, but for the most part, there are obviously these conditions. Again, I use that term, with some hesitation, but exhibitionism, voyeurism, what have you, that is not considered an impairment or a disability. Keep in mind, it notes in there that gender identity disorders is not a disability, which quite frankly it shouldn't be. In fact, the original regulations also said that sexual orientation was not a disability. Duh. So obviously those are not disabilities. With respect to gender identity, quote, disorder, close quote, although that's not considered a disability under Section 504 or the ADA, Americans with Disabilities Act, gender dysphoria has been recognized as a basis for 504 designation. And gender dysphoria, as the slide says, those are situations in which a student or an adult, but again, we're sticking to students here, students are struggling with their gender identity. And so it can result in anxiety, depression, real emotional issues. That is an impairment that can be found to be a basis for a disability in 504. Physical impairment, all the usual suspects, alluding to Casablanca again, neurological, musculoskeletal, so forth and so on. Mental impairment, and this is a little bit more important because I'm going to refer back to it in a later slide. Mental impairment can be a cognitive impairment, bipolar, schizophrenia, something like that. Also, however, can be ADHD or specific learning disabilities, which is kind of interesting because typically if a student has a specific learning disability and requires specialized instruction, they get special ed. But nonetheless, ADHD, ADD, specific learning disabilities, those are important to keep in mind. Now, there are transitory conditions which are also excluded from from 504. They're called transitory and minor. A transitory impairment is an impairment with an actual or expected duration of 6 months or less. Now, I highlighted the highlighting. I used green in the midst of the blue because when you're making this determination, sometimes as to how do you know whether it's going to be transitory? So you use your common sense, your common experience. If it's expected not to last longer than 6 months, then it does not rise to a level of disability that would be covered under 504. So what does this mean in practical terms? A student suffers a concussion or breaks a leg, and concussion is far more prevalent than ever used to be, I think. Either that or it's being recognized far more than it ever used to. If the effects are not expected to last longer than 6 months, then that impairment, it's an impairment. Broken leg, a concussion, it would be an impairment. But despite its consequential limitations, the consequential effects it has on the student, it is not a sufficient basis for finding the student eligible for 504 accommodations. Now, substantially limiting effects of the concussion, this concussion syndrome sometimes can last beyond 6 months. It can be lingering. Well, at that point, it would no longer be a transitory condition. I mean, if it gets to the point where you feel for some reason that this is going to last longer than 6 months, or if you've gotten to the 6 month mark and the student is still suffering these substantial limitations as a result of it, well, then it's no longer transitory. Now it's something that would fall within the ambit of Section 504. I mean, keep in mind, as I put down here, if you decide to find a student eligible for Section 504 services, but despite the condition being transitory, there's no prescription against it. You can do so. It's not like someone's going to come in and write you up, or OCR is going to come down on you because you did it. You can do it. But in my experience, I found that once a student gets on a 504 plan or an IEP, it's extremely difficult to get them off. And you are investing students with civil rights that they might not otherwise have. I mean, yeah, we all want to have our rights, but you might be investing them with even more rights than they would otherwise qualify for.
Mike, if I could interrupt, and this is my own question that came up when I was a school administrator. If a school says, okay, this isn't going to last more than 6 months, so we're not going to put you on a 504 plan, and then it ends up lasting more than 6 months, can the parents then come back at you and say, well, you should have done this from the get-go, and now anything that happened in that time when the student wasn't being treated under a 504 plan now needs to be relooked at, if you understand what I'm saying?
Yeah, no, absolutely. That's a great question. Well, as we know, parents can claim anything. And I could see them coming back and saying, hey, if you had been on top of this and given him or her the accommodations that they needed, then this student would be in a better situation. But the fact remains is that the federal law provides if it's expected not to last more than 6 months, it's not covered under the 504. So I think the school could argue that that's kind of a safe harbor, as they call it in the law. The law has provided us with a 6-month safe harbor, and we were in compliance with it. So this idea that shoulda, woulda, coulda, it's always easy to look at it in hindsight, but we complied with the law, and there you go. So yeah, I mean, a parent could clearly come back and do that, but I'd like to think that they wouldn't have much of a basis for it. But and presumably, let's say you have a kid with I'm thinking of the leg break, the kid with a leg break. Presumably, the district or the individual teachers, let's say, are going to use a little bit of common sense. If you have like a 2-story school and no elevators because it's an old school, I would think that it might make sense to try to ensure that the student, if they can't ambulate, that their classrooms they could attend classes on the first floor. If someone has a concussion and is having issues, hope maybe the teacher would just implement regular education interventions and accommodations. Maybe say, well, you know what, we're going to give you more time to do your work, that sort of thing. And although if it gets to that point where teachers are doing that, the district might say, you know what, let's just put them on a temporary 504 plan so we can get these accommodations in place across the school. Again, there's nothing wrong with doing that. It might be more difficult than to get off the 504 plan, but whatever. But I'm just saying that under the federal law, you do have that 6-month safe harbor where you do not have to provide 504 accommodations. Note, however, that there are impairments that are episodic, which flare up and then go away, and flare up and then go away. I'm thinking of something like celiac disease, irritable bowel syndrome, that when it really flares up, it's substantially limiting a student's ability to maybe sit in class, to fully participate in the school environment. Now, when it does flare up, for the most part, and thankfully, it's not going to last 6 months. So you might say, well, that guy told us that if it's under 6 months, we don't have to worry about it. There is, however, this is an exception to an exception. This is an exception to the 6-month safe harbor. Essentially, this is something that's ongoing. The student has it for more than 6 months. A leg heals, a concussion hopefully heals, but this is something that the student's going to be dealing with probably for the rest of their lives. So you have to, it can be deemed a 504 disability, because again, it's ongoing, even if it's active phases are less than 6 months. Say you know the 504 plan, let's say you do a 504 plan, let's say you find that it substantially limits major life activity. Well, you know, the 504 plan accommodations can be written in such a way as that they're applicable when the student is suffering an active bout of this. So in other words, they're not accommodations that are perhaps necessary the entire school year, but they're written in such a way that, you know, when it is flaring up, the student can avail him or herself of these accommodations. Okay.
Mike, a question came in, is pregnancy a qualifying impairment?
Yeah, you know, in state law, Connecticut does provide for pregnancy can be considered a disability. So yes, I would say so. Obviously, once the pregnancy is over, there's no more basis for it, and pregnancies hopefully are going to last more than 6 months. So I would say yes.
And then the kind of talking about disability lasting longer than 6 months, or will it or will it not last longer than 6 months? Is that based on medical determination, a determination from a medical professional?
I think that would be helpful. Yeah, I do think so. But I mean, I think even in some cases, the doctor is going to have a hard time determining if something, how long it's. I mean, I think with something like a broken leg, most orthopedics doctors could say, yeah, this should, you know, this should be, he or she should be up and ambulating within, you know, 3 months, 4 months, what have you. A concussion, because they have lingering effects, it might be a more imprecise estimation. And if you have a doctor's note that said this is something that could last, you know, for the rest of the school year or something, well, then I think that's something that the 504 team has to take into account, excuse me. Otherwise, essentially, you're making you're taking kind of a wait and see approach. I mean, if based upon your past experience, if based upon your experience, concussion symptoms and consequences have lasted longer than 6 months, well, then I think if someone comes in with a serious concussion, then you could say, this is going to probably last a while. We should probably make the kid 504. Again, there's no prohibition against doing it. If you're wrong, if the kid in 4 months is his or herself again, well, fine. You know, then you take them off the 504 plan. But you know, I think you have to kind of go by past experience. If you have a doctor's note that's definitive, okay, that's great. If you don't have one, and you think, well, I know in the past these kids for the most part have been through in less than 6 months, I think that that's reasonable. Essentially, you just can't be arbitrary. You can't just say, and I'm going to talk about individualized determination a little later, but you can't just say every kid with a concussion gets a 504 plan. Every kid who had a concussion, they're over in less than 6 months, so they don't get 504 plans. You are supposed to make individualized determinations. Okay, major life activities. You know, this always amuses me, the major life activities, and I'll tell you why. In 2008, again, I'm going to talk about that in a few minutes, Congress amended the Americans with Disabilities Act. And as I said, the ADA is predicated on 504. What applies to 504 applies to the ADA and vice versa. But it was not until those 2008 amendments that Congress considered thinking to be a major life activity. I think that tells us everything we want to know about Congress. Concentrating was also added in 2008. But this idea that prior to 2008, thinking was not included in 504's major life activities is kind of an unsettling and amusing thought. All right, so substantial limitation. As I said before, those are the two most important words, I think, under 504. And essentially, there's a situation in which a student is unable to perform a major life activity that the average student of approximately the same age can. Now, unable to perform, that's pretty serious. That's pretty severe. If you're just, not that you perform it in a poor manner or something, or not as fully, but you are unable to perform it. Or they're significantly restricted as to the condition, manner, or duration, and that duration is an important term to keep in mind, under which a particular life activity is performed as compared to an average student. So, it's like you consider what average non-disabled students can do, and then you determine whether this impairment the student has is significantly restricting that that ability of the student to undertake these tasks. So you're looking at the average of performance in the general population, which is an interesting question. So let's say you were in a really high performing district. You are in a very affluent district where the academic standards are unusually high, or they're higher than the state or national average. I don't know if necessarily, so a student who might actually be slightly, their ability to perform these major life activities might be slightly behind, might be average in a lower performing district. And by that I mean, you're looking at the national average, you're looking at the state average, but in the context of this school, it might seem, wow, gee, why can't my child stay up with these the classmates? But it's typically, again, it's the average performance in the general population. General population is not limited to one school district, it's the general population. So, this is this is just something to keep in mind. This is kind of an unsettled sort of issue. Remember, you have to have reasonable accommodations. That's what you have to provide students. I think you all know that. But in the employment context of 504, there's an undue hardship exception. In other words, making this accommodation would just create an undue hardship. Now, that same language is not included in the regulations that pertain to schools. OCR had traditionally applied it, nonetheless, so OCR had traditionally applied it to schools. But there's some 2016 guidance that came out from OCR, which suggested that might no longer be its perspective. They didn't come right out and say it. It suggests it, but it doesn't come right out and say it. I think that there is case law to the effect, and I think that that's something that schools can rely upon. The United States Department of Education, they're the agency that is empowered to oversee 504 through their Office for Civil Rights. And they provide guidance, and they are given some certain amount of deference because, again, they're the agency that's charged with overseeing this and with promulgating regulations. But nonetheless, case law, in my opinion, trumps agency guidance. So there is case law that does say that you can balance the accommodations against the hardships that it would cause to school districts.
Yes. Mike, there's a question that kind of bridges right where you're at from qualifying to accommodations. And the question is, with something like ADHD, where the child is medicated and therefore does not need accommodations, but would the student still qualify because of the disability and have the protections under the law, but just not have accommodations?
Yeah, I'm going to address that in a little while because that is a real sore point for me. And part and parcel of that is that 2016 OCR guidance that I just referenced, which again I'm going to expand upon. Yes, under the 2008 amendments to the ADA, which again apply to 504, and some subsequent 2016 guidance from OCR, districts cannot take into account ameliorative or mitigating measures. It's frankly insane, I think. But if someone's on medication, you're not supposed to consider that medication for purposes of determining whether the student is eligible for 504. However, you can consider it for purposes of determining accommodations. So basically, OCR is taking this position that, okay, you make a student eligible for 504, but you don't have to provide them any accommodations. Well, what's the point? The point, I mean, what it does then is give them all sorts of civil right protections, even though they don't really need them. They don't need accommodations. They're not being prevented from accessing their education. It's truly crazy, I think, and I think it's contrary to the federal law, Section 504, and the cases that have interpreted 504. So I'm going to talk a little bit more about that as we go down the road, because it's just it's kind of zealousness taken to ridiculous extremes. Now, one thing with accommodations, we talked about undue hardship. And that's sort of an open question, though I think typically, as well, I'm going to just cite a few cases here where they do impose the undue hardship exception. But in any event, what is clear is that a school is not required to fundamentally alter the school's program or curriculum. I'll give an example. Let's say you have a student, the other kids are getting 50 questions. Maybe the student, because of their disability, gets 25 questions. Maybe they only get tested on the major focus, the major themes, the major principles of the particular class. Maybe they're given additional time in which to complete their work. Maybe they're given additional time in which to take quizzes and tests. But I think that's all appropriate. But you can't just you're not required to simply say, we're not going to give you any tests, or you don't have to learn this part of the curriculum, or don't worry about it. You're not required to do that, because you're fundamentally altering the school's curriculum, and there is no obligation to do that. The accommodations are supposed to be somewhat tailored to the student, and just to ensure that the student has an equitable opportunity to access their education. You don't have to eliminate their education in order to allow them to access it. That would be obviously internally inconsistent. You just need to sort of help them along. So some court cases, accommodations do not have to be optimal. They merely have to be reasonable and effective. There does not have to be substantial changes to a school's program. I like this. There needs to be a balance between the rights of the student and the legitimate financial and administrative concerns of the school district. So the student is entitled to certain accommodations, certain rights, but they're not necessarily entitled to have everything stood on its ear in order to accommodate them. Again, the touchstone is, will the accommodation give the student meaningful access to the program or services sought? A reasonable accommodation is not one that guarantees the student is going to get an A in the class, guarantees the student's going to be a valedictorian, guarantees that the student's going to be captain of the baseball team. All it means is that they have an equitable and meaningful access to a program. So that's what defines a reasonable accommodation. Some more cases. Again, the undue hardship. An effective accommodation as an alternative to a specific demand can be reasonable. So in other words, the parents might come in and say, well, we want this. And school might say, well, no, the parents want X, school offers Y. And Y is just as effective. The parents aren't necessarily entitled to say, it's got to be this or nothing at all. I'll give you kind of an example. It's somewhat analogous. Years ago, I think it was my second or third special education due process hearing, and the student was severely physically handicapped, and he required a communication device. So he had a computer, he had a keyboard, screen, and as it turned out, it's the only hearing I've had this happen. I actually called a detective to come testify. Because essentially what happened, the family wanted the district to give the student a new and improved communication device, even though this one worked perfectly fine, but it wasn't the most recent iteration of computer technology. The district declined. So what the brother stole the computer, the keyboard and communication device, and then said, well, he doesn't have one. I don't know what happened to it. We don't know what happened to it. We need a new one. So the district, which had been made aware, I guess, by the police that, I say I guess because it was many years ago, I can't completely remember, that this had happened, they gave the kid a letterboard because he could use his hand still to maybe point to letters. So he went to a due process hearing over it, and the hearing officer said, the student's plan provides for a communication device. This is a communication device. This is not the communication device the parents want, but it works. That's reasonable, it's effective, and we won the case. And I felt sorry for the kid because his family ended up really kind of throwing him under the bus. But nonetheless, I only use that anecdote to underscore the fact that it's not the parents' role to determine what's a reasonable accommodation, rather it's the district's.
We're having questions come in fast and furious.
Okay.
So can we go back just for a second in terms of identifying a student for 504? The question is, can schools require documentation from specific sources? For example, a medical doctor versus a counselor in terms of the required documentation to justify a 504?
I tell you, I'm going to tell you what you're getting sick of hearing me say. I'm going to get to that.
Okay.
That's an important issue, and there are permutations to it that you have to be very careful about. So I'm going to get to that in a couple of slides.
All right. And then a question is, an accommodation that reduces the number of assignments in a class for a student okay under 504, or is that altering the school's curriculum?
No, I don't. I think it's fine. I think it's fine. You know, ultimately, the purpose of the school of a class is to instruct a student and to try to help a student gain the appropriate knowledge in that area. And so I know there's some teachers who might give students, you know, homework assignments every night, but it might be determined that maybe this kid has like Epstein-Barr, you know, syndrome, so they have limited vitality. So maybe they can't do homework every night. So what you do is you just kind of focus on what the major, most important points are, maybe giving them assignments on that. So maybe they get 1 a week, 2 a week, something like that. No, I don't think that's fundamentally altering.
Okay.
You get the case by case basis, but you know, so long as the kid is at least given an opportunity to kind of work on and grasp and show knowledge of the fundamental aspects of that class, I think it's sufficient.
And this is a big question, and maybe this is one you're going to come to later as well. And this is about anxiety as a qualifying condition, and specifically anxiety around the pandemic. So in order to justify continued remote learning as an accommodation, even if a school next year, for example, you know, plans to discontinue remote learning as an option.
Yeah, I mean, it's, you know, I've done this long enough where I've seen different, I don't want to use the word fads, but I will, in special education. Anxiety now, I mean, when I first started out doing special ed, I've said this in prior presentations, I never had an autism case for years. And then there came a point where that's all I had were autism cases. Now it's like most of them are anxiety cases. Everyone's anxious. And my standard line now is that it's the kid who says he's not anxious. That's the kid you should be evaluating because there's something clearly wrong with him. So anxiety is pretty prevalent. And with the pandemic, that's a good question. I mean, I would say you would have to go through the same assessment process as you would for any other kid, whether the kid have an attentional disorder, whether the kid have some sort of physical disorder. I sort of think that that's almost, I mean, if you get, under state law, you can get a doctor's note that says this student needs, homebound instruction. Well, if you get something like that, well, then not even under 504, but under state law, and it follows the criteria. And the doctor provides a note, says when the student should be able to return to school. If the district wants their own, is permitted to speak to the kid's doctor. District is permitted to get their own medical assessment to determine whether there's a basis for this. If that all checks out, then under state law, you have to provide homebound instruction, and doing it by way of video as opposed to a tutorial. Well, that's maybe an easier, less expensive way of doing it. But I think, you really have to go through the same determinative steps. And the parent's going to get a doctor's note that says, oh yeah, the kid's all, he's off the wall, and yeah, he's really anxious and he needs to do this. But I mean, that's almost like a form of school avoidance. And I think there's a situation where the school would want to perhaps, I think in that case, they probably want to convene a PPT as opposed to a 504 and recommend a psychiatric evaluation of their own. And then act in response to that evaluation result like they would in any other situation. So again, I mean, it's really kind of hard to say. I'm not trying to dodge the question. It's really hard to make blanket statements. I do think if you have someone who's saying that, it is kind of tantamount to school avoidance. And I think that's why you should refer the kid. And I think you should probably do it to the PPT again rather than 504. And I think that you should probably recommend a psychiatric evaluation. And then, if psychiatric evaluation says, the student should be able to come back to school, then it's like a school avoidance case if the kid doesn't come back. One of the things I hear when I give these presentations on 504 is that people say, and I'm always kind of puzzled by this, well, modifications are not accommodations. If a kid needs modifications, the kid's special ed. No, that's not true. Modifications are a form of accommodation. So if the kid needs some modifications to his curriculum, and I'm not saying you fundamentally alter the whole curriculum, but they need some modifications to the instruction. Sure, an argument could be made that, well, if you're making modifications, that is now specialized instruction, and therefore the kid's special ed. I get that argument. That's an argument that you could be made, but it's not a hard and fast rule. Modifications are, in a way, just another word for accommodations. Accommodations are kind of like this umbrella, this general umbrella, and then what are the specific modifications, accommodations that you're implementing underneath it? So in other words, accommodations are kind of a generic term, and then when you're trying to specify as to what form they'll take, very often they're modifications of like a kid's, school load or something along those lines. So if someone says, oh my God, the kid needs modifications, we special ed. Again, I get it. Where people say it's specialized instruction. But no, it's not an absolute. As soon as you hear the word modifications, it's like all hands on deck. Let's go to a PPT. That's just not how it is.
So kind of related to this, a couple folks have asked about using paraprofessionals in order to support 504 students. And is that a possibility, or is that considered a service?
It's interesting. The law used to be that Part B funds under IDEA could only be used for special ed kids. And then in 2000, I think it was in the 2004 reauthorization, which, boy, hard to believe that was 17 years ago, but that they changed that somewhat. So you can, if you have a 504 student, an accommodation, they can even be in a resource room as an accommodation. Certainly you can use paraprofessionals with them. Now, if if it walks like a duck, quacks like a duck, it is a duck. So if you have a student who you're giving them an accommodation of reading assistance by a special ed teacher, or you have them for trying to get, maybe they have an ADHD or ADD and distractibility. So you're giving them a period in the resource room to try to work on organizational skills. When you're starting to import interventions that are generally limited to special ed kids, it's fine, you can do it. There's no problem with that. But maybe you have to start asking yourself, is this rising to the level that this kid needs special ed? He needs specialized instruction. Are we taking it to the point where it's beyond 504? I mean, I in fact had a due process case years ago in which that's what they were doing. And then the parents said the kid should be special ed and they violated child fine. They should have made him special ed, and district said no. And it was a bad case, and I knew it was a bad case. And frankly, I knew I was going to lose it. And I told the client we're going to lose it, but they still wanted to have the hearing, and we lost it. So it's kind of the Nostradamus of that case. But because the fact is, they were having special ed teachers work with this kid. They had him in a resource room. The 504 plans were even on IEP forms. So when you get to that point, then you should maybe consider whether the kid is at the point of specialized instruction. But as far as the question with respect to paras, although that's sort of part and parcel of the same line of thinking, yes, I mean, absolutely, you can have a para work with kids as 504 as an accommodation. Okay, enforcement, OCR. Keep in mind, however, that 504 is the civil rights statute. So unlike the IDEA, where you have to go through administrative hearings, someone claiming a violation of 504 can proceed directly to court. The only exception is if what they're seeking is available under the IDEA, then they have to go through that route. But so in this respect, 504 is sort of like Title, in the employment context, Title VII, which prohibits gender discrimination or race discrimination in employment. And also, like I said, OCR are the ones who actually enforce it. Okay. All right. We already kind of talked about this. As I said before, the issue that forms the crux of almost every dispute is whether the impairment substantially limits the major life activity. There have been so many definitions of this. Back in 2002, the Supreme Court had a series of cases which culminated in this Toyota Motor case, in which it held substantial limitations means the person is simply unable to perform the major life activity. That was an incredibly high bar. Because most people could perform things, they just couldn't do it perhaps as well as the average peer. So the Supreme Court, and again, this was a couple, 2 or 3 cases in a row where they came up, and again, it culminated in Williams. So essentially, for it to be a disability, the impairment must prevent an individual from engaging in a major life activity. So Congress decided, okay, we're going to rein in the Supreme Court here. Their interpretation is far too much over the top, and we're going to redefine substantial limits. Well, the pendulum swings too far one way, so then it swings too far the other way. So what they said is that, okay, substantially limits where it no longer has to prevent someone from performing a major life activity. It has to materially restrict it. So they go from substantially limits to materially restricts. They take one kind of vague term and they replace it with another one. So it does not need to prevent or severely or significantly restrict a major life activity, which, as I note, is kind of weird because significantly is a common synonym for substantially. So it was really this kind of amorphous gray area. Well, what are we looking at here? Bottom line is, they say, I call it a semantic shell game. When a student has a covered impairment, it still is the case. An impairment is in and of itself insufficient basis for 504 eligibility. There has to be a material restriction. And a material restriction is still kind of a high bar. I mean, material restriction. It's not like, yeah, it has to be an annoyance. Like I say, simple inconvenience, a minor impediment, that is not sufficient. It has to really have a material effect upon the student's ability to perform a major life activity. Talked about before, mitigating measures, you can no longer take those into account. The one exception are eyeglasses. And impairments that are episodic or in remission are to be assessed in their active state when determining eligibility. Obviously, you don't have to sit around and wait till the student is undergoing the agony of a celiac disease flare-up or something like that. But essentially, you have to assess, even if it's in the non-active stage time, you might have to assess, well, when it is active, does it substantially limit, i.e. materially restrict the student from performing a major life activity? So in other words, you have to determine eligibility based upon that active situation as opposed to when it's not active. 2016 OCR ramped up 504 protections. They issued this guidance with respect to students with ADHD, but it's somewhat transferable to Section 504 as a whole. And one of the things that they really were focusing on is the fact that it is vital, this is, I'm quoting from it, that teachers and appropriate staff have access to a student Section 504 plan. Now, I know someone who works at a parochial high school, and they have some students who have 504 plans, but they won't let the teacher see the plans, which of course blows my mind. I say, well, then how do you know? They say, well, they tell you what the accommodations are, but we don't understand exactly the full scope of them. That's a violation of the law. And OCR will use it to find that the school has failed to provide the student with a free appropriate public education, or FAPE. Now, I'm not saying that the 504 plan should be distributed to everybody in the school, all the teachers. To someone who has no interaction with this kid, has no basis for knowing what the kid's 504 plan. So it's not for general dissemination, but it's important that anyone who's going to be interacting with a student, the instructional team, the building administrators, maybe even coaches, if the student is going out for extracurricular activities, is aware of the 504 plan. And what the accommodations have to be implemented. That's just a fundamental violation of 504 if that is not happening.
Mike,
Yes.
maybe this is a good opportunity to ask some questions directly relevant to your last point. What about substitute teachers in terms of being given access to that information?
That's a pretty good question. I mean, I think if it's like a one-day substitute teacher, I don't know if it's really necessary, but if it's going to be a long-term substitute, absolutely. If it's going to be for longer than a day, maybe a few days. I'm kind of making perhaps I'm distinguishing based upon my own time in school years ago. Very often the substitute teacher would come in and, you know, they would have had lesson plan. They wouldn't actually teach per se. They just say, okay, you know, read this chapter or write this essay or something like that. So really not much would be happening. But I do think that, you know what, I'm going to contradict myself and say, I think for the sake of being overly cautious, for being prudent, yeah, they probably should. If it's a student who needs to be able to leave the classroom whenever they want because they have like irritable bowel syndrome or something like that. I seem to be fixated on these conditions, but that doesn't say, hey, where are you going? So they're aware this person's going to do it. If you have someone who's got anxiety and therefore is not called upon in class, that would be something the substitute teacher should know. So yeah, I think it's probably a good idea.
Then we've had a couple questions about different services provided to students. One says, if you provide counseling to a student under 504, do you need to have specific goals like you would on an IEP? And then again, similar, are speech services allowed under Section 504? And if so, who's setting the goals, who's monitoring the progress?
I would say for counseling, there doesn't have to be really goals. It's an accommodation. The student is being provided that to deal with, maybe some anxiety or organization or issues like that. So no, there really don't have to be any goals per se, but the person would have to know, what the situation is, why am I being asked to provide counseling? So I don't think there really are any, there just should be an understanding the student has this impairment, this disability, and counseling is being requested for this purpose, and I think that's sufficient. Now, if you get the speech services, you can provide that to a 504 kid, But speech is the one related service that's considered specialized instruction under the IDEA. So if you're providing speech services to a student, they should probably be special ed.
Gotcha. And then, and this maybe goes back again, someone viewing asks, can we address test anxiety as a qualifying 504 condition?
Well, I guess it really comes down to an individualized determination. Is that the anxiety so substantially limiting that the student just can't take the test or does not do as well on tests? If it's really substantially limiting their ability, and again, there's no bright line rule. It's an individualized determination. If it is really interfering with the student, substantially interfering with the student's ability to take the test, yeah, that could be 504. All right, I just want to go through some of these quickly because I really want to get more to the nuts and bolts here. Academic success can be irrelevant. In other words, you might have a student who's getting all A's, but OCR takes the position that if it's taking that student 6 hours to do the homework, that's taking other students 1 hour or 2 hours to do in order to get those grades. Again, we come down to duration. I mentioned that before. If it's taking the student an undue amount of time due to, slow processing or something like that, that could also be the basis for a 504 designation. I mean, I don't totally agree with that. I mean, if the student's meeting academic success, then homework is not a major life activity. Education is. And if the student's needing all that time to get A's, well, I don't think that it's substantially limiting a major life activity. But that's one of the things you have to keep in mind when you're assessing how a student is doing. So in other words, if a parent comes to you and says, my kid, he should be getting some accommodations because he's doing homework 6 hours a night. What I'm simply saying is they can't say, yeah, the kid's got all A's, go away. You really have to look at it. And you might say, well, okay, we don't think that rises to a substantial limitation, so we're not going to make it 504. Or you might say it does, you're going to make her 504. Again, it's individualized determination. Also, they came up with this 2016 provision that, under the IDEA and under Connecticut's counterpart, you have to do response to intervention. You have to do tiered interventions before you make a child special education. OCR is saying in 2016, no, you can't do that. You've got to evaluate the kid, and maybe you can do the tiered interventions at the same time. That's just ridiculous. The bottom line is federal and state law requires that you do tiered intervention. That is what you should continue to implement. We were talked about this, that, and the other thing. Okay. Oh, yes. One thing about the mitigating measures. OCR says that, well, you know what? If you've got a kid, let's say, who's got a ameliorative measure, maybe it's medication, the child's doing really, really well. Well, what you're supposed to do is you're supposed to say, well, what would it be like if she wasn't on the medication? Or what was she like before she took the medication? Well, she's been taking the medication for years. I mean, how do you figure that one out? Or what are you supposed to do? Tell the kid, stop taking your Concerta for a couple of months and let's see how it goes. They're essentially suggesting you speculate. Let's see what it would be like. What would it be like if the student was on medication? That's insane. It's totally inappropriate. Eligibility determinations are to be predicated upon evaluations, not upon guesswork. This makes no sense to me because you're guessing. The kid's been on medication, the kid's doing great, and you're supposed to say, well, I wonder what it would be like if he weren't on medication. I just find that to be totally at odds with 504. And OCR is OCR, obviously. They've got more power than I do, but I just think that is contrary to the law. And I think you need to take the student as you find the student and you need to make eligibility determinations based upon how that student is doing. All right. This comes back to a question you had asked me before, Bill, from someone. Can you say to the parents, we need such and such? You got to be careful now, because in the same 2016 Dear Colleague letter from OCR, they said that if a 504 team, and I think the same would be true with the PPT, if they were to say, you know what you should do? You should go out and get this medical assessment done. The district has to pay for it. If a team suggests that the student needs some kind of medical test or medical information, you will now be writing signing the check for that medical assessment. So you must absolutely avoid suggesting to the parent that they can obtain a medical assessment. You might say, well, this is going to hamstring us. Well, so be it. I mean, if you want to pay for it, fine. If you think the kid really needs it, fine. I had a case once where we paid for neurological evaluation of a special ed student because the student was essentially, he was in a persistent vegetative state, and we needed to establish that. But that's a rare circumstance. Typically, you don't want to be paying a child's medical bills. So it's very important that you absolutely avoid that. As far as medical assessments go, again, this is one of the common misconceptions I run across. A student does not need a medical diagnosis of an impairment in order to get the eligibility wheels turning. I've heard this so many times before. That's not the case. You recall from slide 11, mental impairments include attentional disorders and specific learning disabilities. These do not require medical diagnoses. In fact, it's very unlikely and very peculiar for a pediatrician to conduct the sort of testing that would result in a specific learning disability diagnosis. So you do not need a medical diagnosis of an impairment to get the eligibility wheels turning. You can get a psychologist or other therapist recommendation. I mean, attentional disorders are very often done by rating scales. You do not need a medical diagnosis. Child find, I think you're all pretty familiar with that. You've got the same obligations you do under the IDEA to identify and locate every qualified student within the school. Okay, pre-appropriate public education. In other words, 504 has the same criteria as the IDEA in that you have to provide a free appropriate public education, FAPE, in the least restrictive environment. Unlike the IDEA, though, that requires specialized instruction, 504, you're just doing accommodations. Extracurricular activities, you have to afford disabled students equal opportunity to participate. As is true with curricular, you do not have to alter the fundamental nature of an extracurricular program. Remember, disabled students have no automatic entitlement to be selected to teams or groups. Their non-disabled peers don't either. I mean, it's not like you try out for a team, hey, you're on it. There's no automatic entitlement. They have to be provided with reasonable accommodations to have an equitable opportunity at making the team or group and is selected to participate. So it's just going to be, you've got to try to make it an equal, even playing field. They don't get preference, but they also they're not at a disadvantage either. Hearing impaired student may be entitled to a sign language interpreter to relay instructions during tryouts, during practices. Hearing impaired student who's like on the track team, instead of a starter pistol, you might have a light flashing to signal the race is beginning. You might need to have someone along the sidelines who can provide glucose testing or insulin injections. Those are not going to fundamentally alter the activity, but they're a reasonable accommodation. A student whose grades have been adversely affected by an intellectual or learning disability. You can't say, sorry, your GPA isn't high enough. You can't participate in sports. If it's the result, if the low GPA is the result of a disability, that can't be held against them. And the court has also held that age limitations do not apply to students who have remained in school past the age of 18 due to a cognitive disability. So those are all reasonable accommodations. Again, it's not fundamentally altering the sport. 504 team. people
Mike,
who have
before you move on,
Yes,
in terms of 504 students and student discipline, do you need to, for example, have a manifestation determination with 504 students and the timings of that and that type of thing?
yes, yes, you do. And I'll go ahead and talk about that now. I was going to talk about it later. Yes, students who have a 504 designation, if they are going to have a, well, hold on a second. I will get to that because that's kind of more involved. Few quick things. IDEA expressly provides that parents are members of the PPT. Section 504 does not contain a similar provision. So parents are not by law a member of the 504 team. Obviously, best practice is to include them. But if parents decline to participate in a 504 team meeting, the team can still meet, can still recommend accommodations. Nonetheless, parental consent is required for initial evaluation. But interestingly, parental consent is not required for reevaluation. So once the student is 504 and you want to conduct a reevaluation for 504 purposes, parental consent is not required. Keep in mind, again, when identifying a student, an impairment in and of itself is not a disability. It's a three-part test. Whether the student has an impairment is just the beginning of the eligibility process. It is not the end. So that ties into the next slide, which is that a doctor's diagnosis is not dispositive. You know, I've had cases where the district will say, God, our 504 numbers is through the roof. And I'll say, well, walk me through the process. Well, if someone brings in a doctor's note and says the kid has ADHD, we make them 504. A doctor's diagnosis is not dispositive. It's a source of information. It is one of the sources of information you have to consider. But all that establishes is that the kid has an impairment. It's still the 504 team's obligation to determine whether that impairment substantially limits a major life activity. Furthermore, you'll sometimes have doctors who say, this student should be special ed, this student should be section 504. That's not dispositive. Doctors make a medical diagnosis, the team makes an educational diagnosis. I've said in prior presentations, I've cross-examined doctors in federal court and at hearings. And in this situation, the questions I always ask and cross are, let me ask you, doctor, would it be appropriate for a teacher to make a medical diagnosis? Well, no, of course not. Then what qualifies you to make an educational diagnosis? Because they are two separate things. The doctor provides evidence of an impairment. Their job is done. Their recommendation is not dispositive. It is just, again, one source of information that you, the 504 team, factor into making as to whether this kid's impairment rises to the level of substantial limitation and therefore qualifies for 504. Evaluations, pretty much just like the IDEA. I'm running low on time, so I want to kind of not focus too much on some of this stuff. You have to evaluate before you can deem the kid eligible for 504. You can't just, you know, and again, that goes to say, like, a doctor gives you a note. You can't say, kid's 504. That's no evaluation. You need to do your own evaluation. So again, doctor's note is just one part of the puzzle. Okay. Now, even though they talk about standards and practices for the evaluations, whether they be rating scales or something along those lines, even something more standardized, you know, like cognitive testing, what have you. But when you get into that much testing, though, it's almost special education. Sometimes testing does not have to be that formalized. It could be record reviews, teacher reports, doctor's notes, all come together, a confluence of information that comes together, a constellation of facts that you then synthesize into a determination as to whether or not the student is 504. So sometimes you may not need as formal an evaluation as special ed kid would. Because again, you're not talking about specialized instruction. You're talking about accommodations. So accommodations is just one page of an IEP, but it's the entire 504 plan. So there is a difference. 504 doesn't say when the evaluations must be completed, but it should be a reasonable period of time. 504, you have the right to have your own people do the evaluations, just like under the IDEA. I've successfully litigated this issue in federal court on both the trial and appellate levels. Schools have the right to have their own people conduct the initial evaluations. So, you know, parents says, oh, I'll do you a favor. I'll have my doctor evaluate the kid. Gee, thanks, but we're going to do our own. You don't want to be bound by someone else's evaluation. Courts have held that if the parents do not consent to testing by the school testers, then you do not make them 504. And I had a 504 hearing once. I served as the 504 hearing officer on a few occasions, but this is one case where I was actually representing an administration in a school district in the hearing. And the hearing officer held, parent will not agree to have the districts assess the kid. The district cannot make that student 504. That was the correct response and the correct outcome, but I was very happy to hear it. So again, you cannot make a kid eligible for 504, just like you can't make a kid eligible for special ed unless you evaluate him or her first. So if the parent won't allow you to assess the child, you can't make them 504. Parents are not entitled to independent educational evaluations under 504 as they are under special ed. I mean, parents can go out and get their own evaluations and you should consider them. But if you do an evaluation, the parent disagrees, they have no right to have the district pay for them to go out and get their own, which is a beautiful thing. As I've told before, individualized determinations, you can't. I was a 504 hearing officer once, and the testimony from the director of pupil personnel was that all kids with food allergies are put on individual health plans. We didn't make none of them 504. I ultimately found for the district, but I did note that that was a violation. You cannot just make blanket applications. Just say every kid who's got ADHD does not get a 504 plan or something along those lines. You have to do it on a case-by-case basis. That's what federal law requires. My one shoe does not fit all feet, as I write, and you need to really consider each child in the context of their disability. There's been some misconceptions about food allergies. It used to be that food allergies never qualified, for the most part, for 504 eligibility. Because the courts essentially said, if you've got an impairment that prevents you from eating, well, that's a substantial limitation. But the fact that you can only eat certain foods, that's not a substantial limitation. You're still able to eat. You just have to avoid certain foods. OCR then, back in the late, following the 2008 ADA amendments, OCR issued some guidance with respect to food allergies. And some attorneys ran around, the sky is falling. OCR is saying every kid with a food allergy has to be 504, no ands, ifs, or buts. That was simply wrong. I couldn't understand why that advice was being given because it was very clear from the guidance. All OCR was saying is that if a kid has a food allergy, you can't just immediately put them on a medical plan. You need to evaluate them in the same manner as you would evaluate any other kid for whom you're trying to determine eligibility. Now, if you have a child who's very young, if you have a child who has cognitive disabilities, if you have a child who's impulsive, a child essentially that can't appreciate the seriousness of the food allergy and might even impulsively grab something and eat something from a classmate in the cafeteria that they shouldn't, well, you might want to put them on a 504 plan because you might need additional accommodations to ensure that doesn't happen. But for kids who are aware of their food allergies, who are very good and scrupulous about avoiding foods they should, a medical plan is probably sufficient. There is no requirement that every food allergy, a student with a food allergy has to be 504. They simply have to be assessed as would any other student. So, individualized determinations. Discipline. 504, like you cannot expel a kid for their disability. So there has to be a manifestation determination. And that's predicated upon a significant change in a student's placement. If you're going to exclude a student for more than 10 consecutive school days, that's an expulsion. That's a change in placement. So before you can do that, you must have a manifestation determination. So the motivation for this is to ensure that the student is being punished for their conduct, not for their disability. And if their disability caused the conduct, then you are punishing them for the disability. If it's not a manifestation, the student is subject to the same disciplinary consequences as non-disabled peers. If it is a manifestation, the student cannot be expelled. Might have to provide more accommodations. You might have to, come up with a different placement, but you cannot expel that student. School has no obligation to provide instruction to a Section 504 or even a special ed kid during the first 10 school days of suspension in any one school year. Upon the 11th cumulative day of suspension, however, again, not consecutive, because if it's over 10 consecutive days, it's a problem. But if it's cumulative days, so kid has 10 days in September, 5 days in December. Once you've hit that 11th day in December, you have to start providing an alternative education. It could be tutoring, could be online instruction, now that that's become so much more part of the mainstream. And you do not have to have a manifestation, although you have to have a manifestation determination if the kid is going to be excluded for more than 10 consecutive days. You do not need to have a manifestation if it's more than 10 cumulative days. Again, you have the kid who's been suspended for 10 days in September, he gets suspended for 5 more days in December or January. That doesn't mean you need to have a manifestation determination. Now, if there's a pattern of removal, so let's say the kid suspended 10 days in September, 5 days in October, 5 days in November, 3 days in December, now you're having a pattern of removals. And that would be seen as a change in placement, and you would have to have a manifestation determination. It's a subjective determination. You got to use common sense, Stu. But yes, I had an expulsion hearing once where I was sitting with the school board, right in the middle of the expulsion hearing, and all of a sudden it comes up, somebody says, well, the student's 504. I said, well, excuse me, but was a manifestation determination conducted? No, I guess we didn't do one. We had to stop the expulsion hearing, and we had to put it on hold until the manifestation determination was conducted. Because again, you can't expel a kid unless you've had such a meeting. Student records, in a nutshell, you are permitted to distinguish between general education curriculum classes and special education classes, or 504 accommodations or modified curriculum on report cards. Because the report cards are simply distributed to the parents and to the student. So you can use asterisks, you can use whatever to show that the student was perhaps graded on a modified curriculum, or that the student was in a special education program. It's on the report cards, it's okay. OCR is okay with that. So it's appropriate to indicate the progress and to, again, indicate that this was a modified curriculum. You cannot, however, put that on a transcript. Transcripts have greater privacy restrictions than report cards. What you can put on report cards, where you designate this as this with a modified curriculum, this with a special ed class, whatever, that's okay. Because again, it's only the parents and the kids who are getting them. But on transcripts that are going to be disseminated to post-secondary institutions, maybe employers, what have you, you cannot have any indication that the student received a modified curriculum or was in specialized programming. Because that's essentially indicating that they're disabled, they have privacy protections, I mean, some people want the post-secondary institutions to know they have disability so they can get accommodations there. But in any event, transcripts have to not reflect any of the stuff. So that's very important. You cannot, any information that the student has a disability or receives special education. 504 also prohibits a school from noting accommodations in any classes on a transcript. Again, report card, yes. Transcript, no. Okay, procedural safeguards. Must be a 504 coordinator to oversee compliance. There must be a grievance procedure. Absolutely must be both a 504 coordinator and a grievance procedure. Notice of the parents and the students, to students, parents and students, that there is a grievance procedure and how to find it, and also how to contact the 504 coordinator. You know, if a tree falls in the woods and no one's there, does it make a sound? Well, it's the same thing here. If you have a grievance procedure or 504 coordinator, but you don't tell anyone how to access them, it's meaningless.
Mike, clarification under the communication about students on 504 plans. The questioner asks, report cards can be sent to other districts upon registration on the elementary level. They often serve as a transcript at the elementary level.
That's fine.
That's okay.
Yeah, that's fine because, you know, it is part of the K through 12 process. You know, the other school really has the right to know if a student is going to need certain accommodations so they can implement the 504 plan or the IEP, you know, when the kid gets there, so they can hit the ground running. So that would be fine. Okay, policy of non-discrimination. You got to probably notice the parents if you're going to do anything with respect to the kids, programming, accommodations, evaluation, identification, anything like that. Again, the parents are not by law members of the 504 team, but nonetheless, they are entitled to notice. Hearings can be pretty funky. I've indicated I've been a hearing officer a couple of times. Some have attorneys, some don't. Some are question answers, some are just sitting around a table and talking. You do not have to allow cross-examination. There does not have to be a recorded transcript. It really is up to the hearing officer and the parties to decide among themselves how they want to proceed. So they're a lot less funky. Well, no, I shouldn't say funky. They're a lot less formal than State Department of Education special ed hearings. Typically, a hearing officer, they are not appointed by the State Department of Education. A 504 hearing officer is appointed by the school district. Sometimes it's like an education professor, very often, generally, and probably preferably it's an attorney because, you know, there's going to be evidentiary objections, that kind of stuff. It can't be the board's normal attorney because that's a conflict of interest. You have to have someone who doesn't normally represent the board come in and be the impartial hearing officer. Okay, reevaluations. These are just some other considerations. 504 doesn't say when they have to be. They just have to be periodic. Typically, if you apply the IDEA's triennial review requirement, that's going to work. There's no stay put. You know, under the IDEA, if someone requests a due process hearing, the last mutually agreed upon placement stays in place. So this happens a lot when it's like a second semester senior who's facing expulsion. And the parents are afraid that he's going to get precluded from participating in graduation. Sometimes, even if the kid's not special ed, they'll file a due process hearing request claiming that the kid should have been special ed. That kicks in the IDEA stay put provision. The student cannot be excluded from school. They cannot be excluded from graduation. And then after graduation, the parents withdraw the hearing request. It's a cynical manipulation of the system, but I've had it happen various times by parents. 504, however, does not have a stay put provision. So if the parent is contesting through a 504 hearing some recommendation or accommodation or finding of non-eligibility or what have you by the 504 team, you can still go forward with it. I mean, again, you need the parents' initial consent for evaluations and so forth. But I mean, once, if you determine the kid's not eligible after the evaluation, the parent can test it, or if you want to remove accommodations and the parents are going to contest it, there's no stay put. I mean, if you want to voluntarily agree to stay put, say, fine, we'll keep the accommodation in place till we've had the 504 hearing. Yeah, sure, that's fine, but you're not required to. Finally, disability harassment is a federal civil rights violation, and both school districts and individuals can be held liable. These are the 5 prongs that the plaintiff must establish. Essentially, it comes down to this. If you are aware of, if you get a staff member or student-to-student disability harassment, and you're aware of it, someone in a position to take action to stop it is aware of it and doesn't do anything, or acts in such an inadequate manner that it continues, that's what's called deliberate indifference. It's essentially intentional. Instead of intentional conduct, it's the intentional actions, it's intentional non-action. And someone can be brought to federal court and sued, like I said, on both an individual and a official basis. It's a high standard of proof, you know, so it's very difficult to make these claims stick, except in the most egregious cases. For instance, and again, it's going to be intentional. So if you had someone who's not implementing the 504 plan because they're negligent or lazy or didn't see the plan, well, that's not a basis for a lawsuit. But if you had someone who's aware of it, and I had a case years ago where a teacher said, I don't believe in any of this crap, to use his terminology, and I'm just not going to do it. That's intentional violation of 504. But if you have someone who just, oh my God, I forgot. Oh, I didn't realize I was supposed to do that. Well, that's, you know, you're being negligent, you're being a knucklehead, but it's not a basis for liability. So, you know, it's something to be aware of. It's something to make sure that just like you would not tolerate racial discrimination, harassment, or sexual discrimination, harassment, you also should be aware that, you know, if someone sees kids harassing another kid, like, you know, throwing their book, someone in a wheelchair, they throw their books down the stairs, stuff like that, saying, wow, kids sure can be jerks. That's not a sufficient response. The appropriate discipline being implemented, that is the appropriate response, so long as it ends up stopping the harassment. So I think I've gone over my time. I mean, if anybody has questions, I'd be happy to hang around and answer them. I know there's a lot of material here to cover.
There are some questions that have come in, and I think most of them are pretty straightforward. So we'll do these, the ones that we have, and then we'll wrap up and we'll see if anyone wants to hang on. So this question,
well, also,
a lot
too,
of,
I'll tell you what, this is my
go
contact
ahead.
information. So if anybody, you know,
Yep.
has a question that comes up later or thinks about it later, that's my email address and so forth, my phone number, so they can always follow up with me. But go ahead.
That's terrific. So a lot of these are around meetings. Frequency of 504 meetings, does it have to be every year?
You typically should be once a year.
Okay.
Now, that's a great question, because under the IDEA, PPTs have to be held at least once a year. It's called an annual review. There is no comparable provision in 504, but I would use 504. I mean, I'd use the annual review under the IDEA as kind of a good guide for that. So you should have it every year.
Should have it every year. Okay, I think it hits. Then this person asked, can the 504 coordinator also chair 504 meetings?
Sure.
Sure. In terms of initial referral, does there have to be a referral meeting, then an eligibility meeting, a placement meeting? Is there a requirement of number of meetings or how those are structured?
No, you know, I you know, frankly, I've seen ones where everything happens in one fell swoop. A parent gives a letter from the Institute of Living saying that the student, you know, has this, that, and the other thing, and should require a 504 plan. That, as I said before, is not dispositive, because the district still has to make a diagnosis as to whether educationally the student needs 504 accommodations. But the district might say, well, we're willing to rely upon this note and make the eligibility determination today, and these are the accommodations we're going to implement. I wouldn't always suggest that. I think that you have the initial meeting, you agree to gather more information and whatever form of evaluations you want to do, and then you reconvene, and based upon those evaluation results, then you come up with a 504 plan. But it's really, again, it's not as formalized and time prescribed a structure as PPTs are in special ed.
Okay. And then someone asks, can you indicate on a clickable tab, such as in Power School, student accommodations so that teachers can easily access them? Or is that too widespread?
Yeah, that would be, the rule of thumb. The rule of thumb in the law, if it's too easy, it must be wrong. So my concern about that, and I'm not a teacher or administrator, so I'm not completely well versed in the ways of Power School. But if it's something that anyone in the school can access, no, you should do that. You should limit it to the individual teachers, instructional staff, coaches, administrators who are going to be interacting with the student. Because then any teacher could pull it down. And I think that OCR would find that is beyond the scope of the need to know standard that they usually use. All
right. Well, we still have some questions coming in, but for your sake and the sake of the audience, give you a chance to catch your breath. So I want to thank you.
I'm happy to answer them, Bill. I mean, I know I tried to cover a lot of information.
Yeah. Well, let me wrap up for everyone else, and then if these folks want to hang on, then we can do so. So, okay. But Mike, I want to thank you for sharing your expertise. I want to thank CAS's corporate partners, Buffalo Wild Wings, Connecticut Army National Guard, Connecticut Department of Public Health, Connecticut Lighting Centers, Horace Mann, Jostens, Liberty Bank, and especially your firm, Pullman & Cumley, for their support of professional development for Connecticut school leaders. I want to thank our audience for attending. I know this information, just based on the attendance and the questions coming in, how important it is to support the work that all of you are doing in your schools. We will have a recording of the webinar available in a few days. You'll receive notification, and the slides will be shared as well. I hope you'll attend future CAS webinars on May 20th from 10 to 11 a.m. Preventers from Jane Doe No More will provide an overview of 6 program offerings for middle and high school students. And these programs cover age-appropriate topics, including sexual respect, healthy relationships, consent, bystander intervention, and cyber and social media awareness. Please visit our webpage at CAS-CIAC.org for details on all CAS events and activities, and check your weekly news blast for information as well. So on behalf of all of us at CAS, I wish you well. Have a great day, great end to the week. If those folks who just put in questions at the end want to hang on, we'll have Mike answer them for as long as he's willing to stay. For everyone else, thank you so much. Appreciate your being here.
Thank you.
All right. Thank you, Mike. So I really appreciate your hanging in. So back to meetings. Is a 504 coordinator required to attend all 504 meetings?
No.
No.
Yeah, and one thing too about the 504 coordinator, particularly in larger districts, there can be essentially more than one. I mean, there can be kind of ancillary 504 coordinators assigned to different schools. In a smaller district, I think one's probably sufficient, but in larger ones, if they feel, well, this is just too much for one person, again, they can delegate authority based upon, I don't know, levels of school, one for all the high schools, one for all the middle schools, or one per school, whichever works best. But no, absolutely not. Typically, 504 meetings are run by building administrators, maybe in some cases, even a guidance counselor. Special ed requires certain people be present. An administrator, a general ed teacher, if the kid has any mainstream classes, a special ed teacher, related service people, so forth and so on. 504 doesn't. 504 just says it should be people who know the kid or have some idea of the kid, or if it's a medically based impairment, having the school nurse there can be very helpful as well. So no, typically building level people would be the ones who'd be running these meetings.
All right. Also related to meetings, when is it mandatory to hold a 504 review meeting? Is it if a student is showing academic or discipline or attendance issues, is that, should that trigger a 504 meeting, or are there other types of circumstances?
Yeah, that's a great question. I mean, yeah, I think if you get to the point where you're wondering, I wonder if we should be having a hearing. I wonder if we should be having another meeting because, the kid's not coming to school much, or he really is getting into disciplinary issues. If you're having that thought, you should probably have a meeting.
Okay.
Yeah.
Some of these are getting somewhat specific. This goes back to manifestation.
Right.
How often does a manifestation need to be held after? So say a student has been suspended for 10 days, you've held a manifestation. Do you then need to hold one every time a student is suspended after that 10th day, or only till it adds up to another 10 days?
Frankly, it's interesting. Under 10-233C of the Connecticut General Statutes, a student can be suspended up to 10 times in a school year or up to 50 school days, whichever comes first. So a student could theoretically have 5 10-day suspensions, and then after that, it becomes an expulsion. Under both the IDEA and Section 504, students are subject to that same ability to suspend. In other words, you can suspend a SPED kid or a 504 kid to the same extent as their non-disabled peers. The only time after that, frankly, the only time you have to, if a kid's not going to be expelled, he or she's merely suspended on multiple occasions, the only time you have to have a manifestation determination meeting is if it's going to be more than 50 days in the course of the school year, or if it's going to be more than 10 discrete suspensions. So you might have 10 2-day suspensions. That's only 20 days, but you've had 10 suspensions. So then after that, it's considered under state law an expulsion. So presumably we don't get to that level. Really, the only time you have to have a manifestation determination, and I know this rocks some people's world, but it's the truth, it's the law, that the only time you have to have a manifestation determination meeting in the context of suspensions is if there are so many suspensions in a short period of time for similar conduct that it becomes a pattern of removals. And that then is considered a change in placement. It's a very subjective determination. But if you're getting a kid who's getting suspended multiple times, like in the course of 3 or 4 months, that you would probably see as a pattern of removals. Then you'd have a manifestation determination meeting to see what's going on. But if you've got a kid who's been suspended 10 days in September, you don't have to have a manifestation determination. Then they're suspended another 5 days in January, you don't have to have a manifestation determination. Then they're suspended another 4 days in, let's say, April, you don't have to have a manifestation determination because they are so separate in terms of time and, possibly they're for different bases. That's not a pattern of removals. So you could have a kid suspended a total of, what did I come up with there? Like 19 days on, cumulative, 3 different occasions, and you still don't have to have a manifestation determination. You only have to have a manifestation determination when there is going to be a change in placement. So.
Gotcha. Okay. So this again is asking for some clarification on when recommendations for service like OT, PT, or speech is brought up during a 504. Are these considered valid accommodations under 504, or should those be, go under a special education designation?
No, that's really an excellent question too. These are all great questions. If a student only requires related services, they do not qualify for special education. The one exception is speech and language. That is the one related service that is deemed specialized instruction. Consequently, if you have a student who may need some fine motor training, so they want to work with an OT, or maybe they have some balance issues and need to work with a PT, something along those lines, that's fine. Those can be included as part of the 504 accommodation plan. There's not a problem with that. And as I said earlier, you can even add speech as an accommodation, but if you're adding speech because that constitutes specialized instruction, you really should be going special ed at that point. But assistive technology, OT, PT, counseling, they're all related services that are perfectly appropriate to be used in the context of 504.
Okay. Going back to transitory impairments, if a student has a broken leg with a cast for only 6 weeks, is a health plan sufficient versus a 504?
Yes.
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 If the student has an ADHD diagnosis and then receives a gender dysphoria diagnosis, should we add or change the disability under the 504?
You can add it. For like in an IEP, you'd want to determine which was the primary exceptionality. The 504, there's really not that so much of a requirement. It's important to understand the IDEA now makes it pretty clear that even though you do list what the kid's exceptionality is, primary exceptionality, planning and placement teams are required to program for the student's needs, not for the student's disability. So in other words, they're guided by what the kid's individualized needs are, and not by, well, he's LD, so he should be having this, or she's ED, so she should be doing this. You really have to be guided by the individualized needs. So in a situation like that, you can list both. If they're both substantially limiting impairments, giving rise of a major life activity, giving rise to 504 eligibility, sure, you can list them both because it shows that you're on top of things, that you're not ignoring one thing or the other. But ultimately, the accommodations, just like they would for the special ed, the accommodations have to be geared to what are the kids' individualized needs. So yeah, that's fine.
Okay. And are there model 504 plans? I mean, IEPs have to have certain information by law. Do 504 plans have a certain format that they must follow? And if they do, are there model plans that,
Yeah, the state
and there's a
Department of Ed
resource
might-
for those?
Yeah, that's a good question. 504, I thought that there was, just like there was IEP Direct, although now I think the state's moving to a different program. I thought there was 504 Direct as well. Typically, though, you would have, obviously the kid's name and date of birth and grade and so forth. You would typically have the, impairment, how it's substantially limiting, what major life activity it's substantially limiting, and the student's accommodations. Those things have to be on there, and also the names of the people who are part of the team, that sort of thing. So, kind of the basic nuts and bolts information.
Mm-hmm.
Again, that's a great kind of neat thing about, one of the things when I'm giving this talk, I forgot to do it this time. If you look at the IDEA regulations, they're like an inch or so thick. If you look at the 504 regulations, they're hardly thick at all. 504 is really a lot loosier goosier, so to speak, to use legal terminology. So they really don't get as prescriptive as the IDEA regs do.
Right. Well, we've exhausted all the questions, and I'm sure we've exhausted you with
That was fun.
making you spend this extra time, but it just shows the level of interest or need or anxiety about 504 and these issues. But again, just want to thank you so much on behalf of CAS. Thank those members of the audience who are still hanging in there for the information. And it's just been terrific. And we look forward to having you back as always. And we'll give you a chance to recover. But again, thank you so much. It's been a terrific presentation and really appreciate you taking the time this morning.
Well, thanks, Bill. I know there's a lot of material to cover, and I think I kind of ran short on time because, like most attorneys, I'm too verbose. But Well, yeah, I appreciate it. I enjoyed it. Thanks for having me.
Very welcome. Thank you. All right,
Okay, take
thanks,
care.
everybody. Have a great rest of your day.